So I'm going to start out this morning by giving you a little bit of an update on where we stand with the whole waters of the U.S. issue. As many of you have probably heard, this has been in the news for the last couple of years, and what you see up here are a couple of different views about the effort. And so just to see the contrast, the top is from an EPA press release as they put out this rule. Basically says they're taking the action to provide clarity, make sure that the regulated community knows exactly where the borders are. The lower quote, and this is from comments issued by the American Farm Bureau Federation, but these comments mirror many other groups, not just in agriculture, but across the board, many other development groups, those involved with building roads or cities or power utilities and those sorts of things. EPA received a lot of comments expressing the same view. And I think it's interesting to note that while the intent of the rule, the new rule, was supposedly to provide clarity, it still refers to an awful lot of examples where determinations of jurisdiction would need to be made on a case-by-case basis, which is exactly the thing that the preamble to the rule suggests the problem they're trying to solve, the elimination or reduction in case-by-case jurisdictional decisions. I also want to make sure that it's very clear across agriculture, we're all shoulder to shoulder. I work with 25 ag groups in Minnesota, and every one of those groups expressed similar views in their comments made to EPA on this proposed rule, essentially calling for them to go back to the drawing board and rewrite the rule. So this is a timeline, and you can look and see when the proposal became public was in April of 2014, but we know based on technical documents that we've reviewed that EPA was actually in the process for at least a couple of years prior to that time. You have to remember this rule itself is more than 300 pages, and the underlying technical review paper is almost 400 pages of material that go along with it. The comment period that was open in 2014 was actually extended twice because the EPA had so many comments coming in. They ultimately received more than 1 million comments on their proposed rule. During that time, and continuing yet today, this proposal has run into some roadblocks. The House of Representatives has voted on multiple occasions to stop implementation of the rule. The Senate has tried, but been unsuccessful in actually passing similar language. But they have passed a resolution simply opposing the rule, and there have been efforts to try to stop it through funding. So legislatively, there are some things going on that potentially could address problems associated with the rule at some point. Meanwhile, the courts are also acting. And so as this rule became final this summer, initially a court in North Dakota issued an injunction stopping implementation of the rule in 13 states. And so it was somewhat disappointing then that the 37 other states, including Minnesota, the rule technically was in effect for a short time. But later in the fall, about 3 months ago, a court in Ohio issued an injunction that effectively stopped implementation of the rule nationwide. So we're waiting on decisions in that case, but ultimately the major two sticking points that we're watching in that decision out in Ohio is, did EPA exceed their authority in the way they went about writing the rule? And secondly, did they violate the administrative process by making substantive changes to the rule between the initial rule and the final rule based on comments that were such large changes that they should have opened the new rule up for a comment after that. And that is the update that I've got on waters of the U.S. Just a couple of general comments before I turn things over to Joe to fill you in on buffers. There are some things that you as farmers can do to be involved in this process. I think it's important to note that your legislators need to hear from you what your thoughts are about the proposed rule. And I think it's important to send them a clear message that this is not about whether we're for or against clean water. It's how we get there. I think we're all in support of seeking to protect the water resources we have in our state and in our country. This has never been about that. I think it was especially disappointing that in issuing the final rule this summer, in their rollout of the final rule, EPA said only polluters could dislike this rule. I don't agree at all. I think many others, including folks in this room who are proponents of clean water, are opposed to this rule on the basis of how it would go about regulating, and specifically how it could go about regulating agriculture. Even the GAO came out with a report recently saying that the EPA and the Corps went too far in using propaganda, that was their word, propaganda, to support the rollout of the rule. And I think, again, that's a signal that when a rule is combined with that level of promotion and politicking, it tells us there's probably an underlying problem with the rule. So those are the keys I wanted to make sure you're aware of. Are there any questions specific to waters of the U.S. before we move on to buffers? Quiet. Well, we'll talk about buffers, and then at the end, Joe and I can perhaps answer any questions that might come up together. So, Joe Smentek with Minnesota Soybean.
Thanks, Warren. Just a little bit about myself before I start. You guys probably all know Warren, but probably aren't as familiar with me. I'm an environmental attorney. I've been working with Minnesota soybean growers now for the past 2 years. I run the environmental stewardship program there, along with our advocacy work that we do. Before that, I was a prosecutor in Nicollet County and Martin County, so did a lot of work on drainage, ditches, that type of thing. Also prosecuted lots of felony drug cases, so I got a lot of good stories if you want to hear those, but those aren't for this talk, I guess. Before we move on to buffers, I just quickly wanted to highlight another effort that WOTUS, WOTUS isn't going to go away anytime soon. It is rearing its ugly head in other ways that not everybody in every state agency in Minnesota is happy that this law didn't get passed. And so there are other attempts to get WOTUS basically written into state law, which would be allowed by the Clean Water Act. States can be more restrictive than the federal law. They can't be any looser. So right now there is a 404 assumption study going on that the legislature ordered last year. Basically what that is the dredge and fill permitting that's done by the Corps and by EPA. The state's looking at taking that over. One of the keys to to be able to do that is the state would need to have all the jurisdiction that the federal government would have over wetlands and rivers, streams, where a dredge and fill material permit would be necessary. So EPA has to basically negotiate with the state if the state wants to do this, and there are a number of agencies in the state that do want to do this to streamline the permitting process. And that sounds like a good thing for most people, to streamline the permit. You don't need to go to a few different agencies. But the problem we have in Minnesota is right now all the permits are done at the local level. And that won't pass the EPA's requirement that the state have control over the waters. They're going to want that done through the Board of Water Soil Resources. And they're going to be looked at to take over permitting, which is now done on a local level, and do it on a state level. They also will have to come up with more enforcement mechanisms for people that are in violation of permits. So, for example, the federal statute right now is $10,000 a day. Minnesota doesn't have anything near that. So they'd be looking at adding basically the Waters of the U.S. authority to the state agency in Bowser in order to accomplish that. They think the court case, as Warren mentioned, that is going on now is challenging the rule on its face. I think there'll be more challenges to the rule once it's implemented, if it is ever implemented. Basically, the underlining case law that they use for that doesn't agree with what they did. They stated that they were using a plurality opinion, that they were going to go ahead and use this language for the test to take and put into the waters of the United States. The problem they have with that is that the Supreme Court decision said that a water has to affect the biological, chemical, and physical makeup of a water, an adjacent water. What they changed it to was or. So now instead of jumping 3 hurdles, you only need to jump 1. And that it doesn't fit with the current law of the nation as far as the Supreme Court laid it out. So when you do see it finally enacted, if they enact it, you're going to have another court case pretty quickly. With that, we'll move on to buffers, which are oh so exciting, I know, to everybody, especially in this warm room. Buffer law was passed last year in the first special session, Chapter 4, Article 4. Section 79 of Minnesota statute lays out the general requirements for the buffers. There's two different designations, the first of which is public waters. Public waters are a defined statutory creature. However, they decided to change that. So they're in the process of making maps of what these public waters are right now. No outside groups have been involved. It's being done internally at the DNR with their staff and their attorneys. So we have no idea what criteria they're actually using for these public waters. But the public waters basically will have to have a 50-foot average with a minimum of 30 feet, so in no place can it be less than 30 feet. Or you're going to have to follow the shoreland standards set up under Section 103F, which are basically the zoning standards we have in place today that were in place prior to the buffer law. So you're going to have to follow whatever is the more restrictive of those two options. In most cases, that's going to be the shoreland ordinance because that requires a 50-foot buffer everywhere. That doesn't have the 30-foot minimum language in it at all. The deadline for those is going to be November 1st, 2017 for all of these designated public waters. The agencies are supposed to be sending out maps to all affected landowners, so that won't be necessarily the person renting that farmland that won't get a notice, but the landowner will get a notice on whether or not they are adjacent to one of these DNR public waters. So it'll be important for farmers that are renting land to work with their landlords to make sure that they are in compliance or know if they have one of these areas. The required buffers also has an alternative language that I'll talk about a little bit later. The other category of waters is the drainage systems. Drainage systems are defined a little bit differently in two places, but basically what this says in the new law is that any ditch in a benefited area, which is a defined term in statute under 103E, where ditches benefit, what land is actually getting a benefit from being drained by that ditch. So what they did was they took and said all the public ditches, and including any ditch, so that would include any private ditch in their reading, from having to have the 16.5-foot buffer, as long as that ditch is in a benefited area. Right now, they are in the process, like doing the public water maps, of mapping out where they believe all these ditches are. And this will be another instance where landowners will have to be very vigilant on making sure that things like grass waterways or, scrape ditches aren't included in these maps, the things that aren't actually a ditch, that don't have water flowing in them regularly, so they don't get included into these maps. The requirement for the buffers on the drainage ditch is a year later, beginning November 1st, 2018. There are 5 exemptions. I don't have a slide for this, but there are a number of exemptions in Subdivision 5. I guess there's 6 of them to the buffer rules. And these are if the land is enrolled in CRP, a Conservation Reserve Program under the federal government. If they are used as a public or private water access, including a recreational area, so if you have a beach along your ditch, it's exempted out. If they are covered by a road, trail, building, or other structure. I know I'm on the Planning Commission in Blue Earth County, and they've received at least one petition to build a building all along a ditch so that they won't have to put in a buffer. Also, if it is within a city limits. The city limits has a special exemption under their NPDES permits, which was not granted to livestock agriculture, even though the NPDES permit that you would get would be similar to what the cities get. If it is part of a water inundation cropping system, it would be exempted out, along with a exemption for tile maintenance, installation of tiling, or the planting of perennial crops, basically the planting of a buffer. If you decide you want to do alfalfa in there, you tear out the buffer to plant the alfalfa, that would be exempted out for that period as long as you were trying to establish some permanent vegetation in there. The basic buffer requirements under this is the landowner owning the property may meet requirements by adopting an alternative riparian water quality practice or combination of practices based on NRCS Field Office Technical Guide or other practices approved by the board. This provision here that is in the state law is very interesting in that most of this stuff is not defined. So it states that it has to provide water quality protection comparable to the buffer protection for the water body that the property abuts. None of that is defined. None of that is laid out as to what the benefits of a buffer are for different bodies of water, what practices are included in that, other practices that would be done in your field, what other practices could be applied to the land. None of that is defined at all. So at Minnesota soybean growers, with the Research Promotion Council, we are investing checkoff dollars now into a project with Houston Engineering. Houston Engineering is looking at 4 different watersheds for us across the state. And what they're looking at is what would a general engineering study look at as far as what those buffer benefits are. And then looking at what practices could be done to reach those same level of benefits that would be agronomically practical, that would make sense to for a farmer to use, and maybe actually in most cases better for water quality than the buffer itself would. So hopefully we'll have that document there, about 75% done with that study at this time. They'll be finishing that up and will hopefully be coming out with some type of handbook. This will be important for farmers, I think, for a number of different reasons. First of all, every watershed is going to be different, and as you guys know, across the state, some watersheds are more farmer-friendly than our other watershed areas. So this will be a document that hopefully in those areas where these alternative practices are frowned upon, we can actually, farmers will actually have a tool as far as an engineering report to combat some of the agency just denying alternative practices. We've also been working with Bowser and the Association of the Board of Soil Water Resources to basically take this engineering study that we're doing and is adopting it as some of those approved alternative practices. So this is pretty self-explanatory here that the County Watershed District Board of Water Soil Resources may issue a fine of up to $500 for noncompliance. So it's not a huge amount of money. But they can go further if there's a removal or a degradation of a buffer. They can look at more severe penalties, and they're in the process of coming up with what exactly those penalties are. So we don't know that at this point. Basically, they were given the authority to come up with them on their own by the legislation, and that is what they are doing. If you do live in an area, I know I've talked to a couple different soil water area conservation districts that really aren't excited about this. They don't see a huge problem with the buffers the way they were enacted. If they don't get on board with this, the Bowser does have the ability to withhold their funding, and so it can really hurt them, and I don't think that'll be a very good thing in the end. So the key with the buffers, these are recommendations from Warren. I'm a lawyer. I tend not to write things down, so Warren might be able to speak better to these, but I agree with definitely some of them, knowing your options, knowing your rights, and your obligations. You do have a lot of number of options under this law. It's very broadly written, and there are, even in the buffer definition in of itself in public waters, you have 2 things that you may or may not be able to utilize. You may not be able to utilize that 30 feet minimum. So before you go out and do something, thinking you're okay because you have a 50-foot average and a 30-foot minimum, you really need to talk to the Soil Water Conservation District people in your area, even if you don't get along with them, even if you don't like them, just to find out what they're thinking. It would be a shame, basically, to go out and waste a lot of money on a buffer that at the end of the day they're going to not approve because they don't believe it's the least restrictive alternative. Like we said before, the counties will be sending out these maps. The maps are basically going to lay out where these buffers are needed, and you will have a right to challenge those maps. You don't have to just take them and say, okay, and go put in a buffer the next day. You do have a chance to challenge what they're laying out and whether or not a buffer is needed in that area. We know a lot of ditches that the spoil banks slope away from the sides so that there's no water getting in there from overland flow, so there would be no buffer benefit. And really understanding that and looking at what your situation is before you get bullied into putting something in by a soil water conservation district. And that's all part of the ground truthing those maps. There will be a number of alternatives that will be available. Like I said, we'll be working on some. I know other farm groups are also working on what some of those alternatives may be. And don't limit yourself into thinking about just simply if I have to have a terrace, I have to build a berm. But there are other things in that NRCS technical manual that could help. Putting in cover crops along the edge of a field, not the whole entire field, just the edge of a field, could have the similar benefits as a buffer. Doing different tillage along those areas along water could have the same benefits that a buffer would have. So really looking into those options and talking with the different engineering firms, or if you have a good soil water conservation district, talking with them about what some of the other things that are available to you will be really important, I think. Yeah. Looking at cost-sharing options, if you do determine that buffers are right for your farm, there are a number of different programs available to you, and CRP and RIM, other programs. There are pitfalls with some of these programs. Obviously, RIM is a long-term tie-up of the land. It's going to be permanent easement on that land. You're not going to be able to do anything with that land into the future. Depending on your county, some counties will take that into account and tax it accordingly. Others will look at it and say, well, there are some things you could do. You could hike out there. You could still hunt on that. So they'll tax it at a recreational value, which may be higher than a conservation value. So looking at all those ramifications is important before you tie up the land, especially in a program that's a permanent easement type situation. Also, just talking with the landlords and tenants, getting together and talking about what some of these options are. This could be, we've done a study when this was first announced. It could be anywhere from 125,000 to 400,000 acres that are affected, depending on what they decide that these public waters will look like. With the impact of 400,000 acres across the state, that could be a lot of farmland that's taken out of production. And before your landlord goes out and does something on the land that's really going to affect it, such as RIM or putting in these buffers, looking at the other alternatives that could be done pretty cheaply and easily by farmers is really important to make sure that this land isn't lost to production agriculture and to your bottom line, basically. That's the exploring the alternative practices. The other important things, there's been a lot of the hunting groups that have been touting all this new land that's going to be available to hunt. You need to remember that the new law does not give anybody any access to your property. These buffers are still your property. You can deny anybody you want the right to go in and hunt on them. There's no open walk-in access provided under this buffer law. So if there is buffers that you need to put in, you still have the right to exclude the public from that land. You also have the right to use that land in haying, grazing, or just to mow that buffer, as long as the permanent vegetation is maintained. So there are some new crops that the University of Minnesota is developing. Don Weiss is developing Kernza. It's a wheatgrass that is a perennial wheatgrass that may be able to be grown along the edge of a public water and still farmed. They're working at creating a market for this crop. It's a non-GMO wheat that there's a couple different groups. General Mills and Patagonia are interested in purchasing this and using it in different products. So they're excited to get that to market, and it may be an option for your farm to keep some economic viability on that land that you may need to just be profitable. And that is all that we had for about buffers and the WOTUS. Of course, there are a couple other issues coming up. The governor has announced his water summit that will be held in February. The governor's water summit filled up in about 30 hours. There was 1,000. It was limited to 1,000 people. So a lot of farm groups were shut out from that. Before they even got out to us, basically, there was environmental groups that had about a 12-hour head start on signing their people up before we even got the email. So it'll be really important for farmers and agricultural employees in general, just to get their voices heard to the governor. There is a survey that the governor has regarding that water summit. The answers are garbage, basically, for farming. The answers treat you like you are all one-size-fits-all little people play set farmers, and that you need clean water for your crops. You know, majority of farmers in Minnesota don't irrigate, so you don't need to pull water out of a lake. You don't need to pull it out of a river. It falls from the sky for you. So that it really doesn't answer what agriculture's concerns are regarding these efforts under clean water. So filling out that survey, even if you're not going to be able to go to the water summit, is really important. If you do sign up for the Water Summit, there is a wait list. So if you have any interest at all, I would highly encourage people to sign up. The bigger that wait list is, hopefully we can put some pressure on them to change the venue to allow more people in, especially voices that don't necessarily get heard all the time in the governor's office. So fill out the survey, sign up if you need to, and I think with that, if there are any questions on any of this stuff, Warren and I would be happy to answer them.